Hi, I'm Max Dilendorf, New York-based attorney. My firm advises international families, investors, business owners, and foreign professionals relocating to the U.S. on pre-immigration tax planning. If you are planning to move to the U.S., there is one number you need to know. That number is $60,000. Because under U.S. estate tax law, non-resident who owns U.S. assets could be entitled to only $60,000 estate tax exemption. Let me explain why this matters. If a foreign national owns a condo or other real estate anywhere in the U.S. worth, for example, $1 million and passes away while classified as a non-resident for estate tax purposes, only $60,000 of that value is exempt. The remaining $940,000 could be subject to U.S. estate tax at rates reaching up to 40%. So that could mean a tax bill of $350,000 to $400,000 on a single $1 million property or other types of U.S. citus assets. Now, let's take a look at the rules that apply to U.S. citizens. For 2026, the federal estate tax exemption is $15 million per individual. Married couples can combine their exemptions and protect up to $30 million from federal estate tax under current law. So think about the difference. One system allows $15 million per person in estate tax protection, and the other allows only $60,000 for non-U.S. residents. So the gap is pretty staggering, and here's where the real tax trap begins. Once you become domiciled in the U.S. for estate tax purposes, the exposure can expand beyond U.S. real estate. Under federal law, specifically Title 26, United States Code, Section 201, the estate tax applies to the worldwide assets of individuals who are domiciled in the U.S. at the time of death. So that means not just U.S. property, but also foreign real estate, investment accounts, crypto, stocks, ownership interest in private companies, and family businesses anywhere in the world. In other words, once U.S. domicile is established, your entire balance sheet could fall under U.S. estate tax system. A lot of people think that being in the U.S. on a temporary visa like E2, H-1B, or L-1 automatically protects them from this kind of exposure. The same misunderstanding often comes up to so-called gold card investor visa program, but that assumption is not accurate. For estate tax purposes, domicile is based on physical presence and intent to remain indefinitely, not simply your visa category. Immigration status and tax domicile are separate legal concepts. If you later get a green card, including through EB-5 program, you also become subject to U.S. income tax on your worldwide income. For example, if you purchased a property in Spain or another jurisdiction years ago for $100,000, and after becoming U.S. permanent resident, you sell it for $1 million, the United States will generally tax the $900,000 capital gain, although the property is located overseas and you were not a U.S. resident at the time you originally purchased it. The same principle applies to foreign securities, crypto, private equity holdings, operating businesses, and other appreciated global assets. So that's why pre-immigration tax planning is so critical. The key is to restructure assets before U.S. tax residency or domicile is established. There are sophisticated and compliant strategies available. These may include U.S. and offshore trust planning, corporate restructuring, and insurance-based solutions like private placement life insurance or PPLI. When structured properly before U.S. residency begins, PPLI can allow investment assets to grow inside a life insurance policy wrapper. Under U.S. tax rules, growth inside the policy can accumulate on a tax-deferred basis, and policy proceeds are generally received income tax-free. For international families with concentrated stock positions, private equity holdings, digital assets, or operating businesses, PPLI can create tax efficiency, estate planning, leverage, and asset protection, all within a compliant structure. But timing is everything. Once U.S. domicile or tax residency is established, many planning opportunities narrow significantly or disappear altogether. So if you are thinking about moving to U.S. under L1, E2, H1B, EB5, or Gold Visa program, advanced planning matters. When done correctly, it can protect significant wealth for you and your family. If you would like to discuss your situation, reach out to us for a confidential consultation. Thank you for watching, and I will see you in the next episode.